Hey, Kevin.
Hello, Rebecca.
Guess what we're doing?
Another emergency readathon.
Oh, my goodness. What a day. All right. Little piece of news I just want to share first. The Commonwealth has filed 2 additional motions today. I don't have full news on them, but I do know one thing. They have requested to add to their witness list 3 members of Karen Read's legal team. David Yannetti, Alan Jackson, and Elizabeth Little.
Well, I mean, is not the defense team like at requesting the district attorney and shit like that?
Oh, that came up today, believe it or not. And we learned a little bit more about what they would plan to do with them. And I don't think it was unallowed. So there were 2 hearings today. Not 1, but 2. The first hearing was based on a motion filed by the Commonwealth in Karen Read's case, but it involved Aidan Kearney / Turtle Boy. So Hank Brennan, in the same courthouse, in the main courtroom, argued this case in front of a judge named Judge Doolin. This was his plan. And Turtle Boy was there with his legal team, Attorney Bradel, etc. And the plan was he was going to go in, and what he wants was, his motion says, I want like this broad swath of communication and data from Aidan Kearney's phone and other devices, his 2 phones, etc., to show Karen Read's consciousness of guilt because of communications with him through an intermediary and because of her direct communications with them, et cetera, et cetera. There was a complication here.
Okay, what was that?
He filed this case under Karen Read's case number. So soon after he began arguing this motion in front of the judge, now picture the scene. He's there in the main courtroom in the courthouse. He's arguing it. Aidan Kearney and his lawyer are sitting at the defense table, right?
Right. And which prosecutor is this? Is Brennan?
This is Brennan.
The special, okay, yeah.
Yes, this is Karen Read's prosecutor, Brennan.
All right. And just so we're clear again, this is a hearing about witness intimidation by Turtle Boy?
They're calling it consciousness of guilt evidence, that her communications with him to get him to intimidate witnesses implies consciousness of guilt, and they want to bring this into the trial.
Okay, all right.
Picture the scene. He's there, Turtle Boy, with his lawyers. Brennan walks in, starts to make his argument. The back door of the courtroom busts open. Karen Read, Alan Jackson, David Yannetti, Elizabeth Little walk in, and Rob Alessi. Karen Read walks up to the front of the court and sits down at the defense table next to Aidan Kearney. And Brennan is like, I'm confused. What's going on here? Why is she here? And almost immediately, this Judge Doolin, basically says to, after a little bit of conversation with Jackson, says to Brennan, yeah, I'm allowing her to sit there. This involves her.
Thank you.
Well, Your Honor, I do object. Ms. Reed's counsel and Ms. Reed do not have standing for this motion. I don't believe they should be sitting at the table for this motion. It's a Rule 17 motion of third party. She has no privacy interest in these materials. She has no standing to object, and she's not a party on the Rule 17.
Thank you, ADA Brennan. She is a party in this case, and I'll allow her to sit at counsel table and to have representation, and I'll consider whether I'll hear from her counsel concerning the substance of the motion and her considerations there too.
We appreciate the court accommodating us.
What happened was Brennan immediately, by the way, started getting asked very detailed questions by this judge, which we haven't seen before. And to me, really highlights the difference between a judge like this, I will call him a regular judge, and Judge Beverly Cannoni. This is not my observation alone. I promise you.
Yeah.
If you look at even neutral trial watchers who just tweet about this, they're all like, oh, this is new. This is different.
I saw 60 seconds of this hearing, and like, this is a different judge. Yeah.
Yes. He's like, what's the scope of what you want? What's the data for how you want? Where's your proof of what you want? So after this bust-in by Karen and her legal team, Alan Jackson says, I don't mean to interrupt Mr. Brennan's argument, but
of course I do. But go ahead. Yeah.
I need to talk to you about why she has standing in this case. Because Brennan was basically saying she has no standing here. Why is she here? Why is her team here? And Jackson's like, because it's filed under her case number. And because you are asking for information that you were going to use in your prosecution of her, of course she has standing. There was a little back and forth whether or not these were evidentiary issues or issues of standing. The judge seemed to give him enough leeway that he let him make a long argument and, yes, interrupt Brennan's case and let Karen Read sit there. So
this judge didn't take 3 weeks to decide whether or not.
Well, no, he hasn't decided yet.
But he let him sit at the table. I mean, okay, it wasn't paralyzed with indecision.
Yes.
All right, gotcha.
And we got to hear also from, if you haven't been watching any of Aidan Kearney's procedural stuff, Attorney Bradel, his attorney, is unbelievable when it comes to getting the fuck to the point, making it clear, and saying why this is like bananas. He's like, a quote, they're trying to hang on to their, quote, bizarre interpretation of the witness intimidation statute to get what they want, he said.
Right.
He talked about the taint team issue. I don't know if you know about this, but in Aidan Kearney's case, apparently the Massachusetts State Police took his devices, extracted all the data before they were supposed to. It was supposed to go to this taint team, which would extract everything and then redact stuff, like personal stuff, attorney-client privilege. The prosecution in his case says, oh, well, we got it all, but we haven't looked at it yet, which is not true. They've had it for years now. And so, so that's what happened. And the judge said he'll take it under advisement as to whether or not he will allow, Brennan to have this material. He still hasn't decided that. But he did seem to bend on this, yes, being an issue that Karen Read does have a stake in. So that was just fascinating to watch.
Yeah.
Fascinating.
Yeah. But was this the judge that was involved in the witness intimidation stuff against the guy from Canton Fence?
I don't think so, no.
Yeah.
I don't think so, no. But this was a very competent, interesting judge, and I don't believe it's the same judge.
Yeah.
But
so the Commonwealth keeps trying to make this case that Aidan Kearney and Karen Read are in cahoots, and the things that Aidan Kearney doing, not only directed by Karen Read, but what he is doing, and those things in his news gathering amount to the legal definition of witness intimidation, and they haven't been able to get any indictments on that, but they keep bringing this up.
And the judge kept calling Brennan on the fact that he was not providing a reason, essentially saying, why do you need this to be able to prepare for trial? Like, what do you know you're going to get from here that has an evidentiary value? And he's basically like, well, we assume we're going to see this. We've heard we're going to see this. Elizabeth Little got up and argued and said 2 brief points. She argued very briefly and succinctly.
This is one of Karen Read's attorneys. Yep.
Yes, the Commonwealth affidavit is insufficient. There are no facts to show that they cannot properly prepare for trial without this evidence. On that basis alone, the motion should be denied. And the Commonwealth is required to show this is not a fishing expedition. They list no facts to support this is not a fishing expedition.
Yeah.
And the Commonwealth well knows, she said, the grand jury's decision on this matter, this is facially deficient, period. They're just trying to go around the fact that the grand jury found nothing. So anyway, that's what happened there. Very interesting. Next up, there was a Karen Read hearing today, another evidentiary motion hearing. Okay.
Well, we left the big one last time. Is the trial date pushed back a month?
No.
Oh, even though both sides stipulated that they wanted this, Judge Bev says no. What, because the jury pool is going to be a party? What the hell? To
be fair, the Commonwealth's position was we understand why they want this, Karen Read's side, and we are okay with it especially if the court rules quickly, which they have indicated they will do.
Yeah, so not stipulating, but we're not going to object to it.
Right. They basically said we're not object to it if we can come to some reasonable compromise. Sure. The 25th thing they didn't seem to have a problem with.
Yeah.
Bev Canoni was like, I'm not doing that. I am beginning to impanel this jury on April 1st, period. She says that could take goodness knows how long. And
until
by
April
then
25th,
the decision may have come in. Right. So, I don't think it was necessarily an unfair thing for her to say. That being said, it was a little bit surprising insofar as that usually when both sides agree to something, the judge is more likely to say, sure, no problem.
I feel like maybe she has just a little bit of confidence that, at least in her mind, that she is not going to be overturned on,
so
on
do
her
I,
decision.
by the way.
Yeah, I mean, she's just like, I'm not going to, none of the appellate courts have ruled against her on these different matters. So she probably just feels like, I'm not going to delay this any further on the off chance I finally get, and this is what, they're trying to determine whether or not this was a judicial error, and in any event.
That's right.
Yeah.
That's right. So that motion's done. Next motion up was the Commonwealth's motion to extend that buffer zone. Mm-hmm. Remember that?
Yeah. Does that also include the apparel? Is that the same?
Yes, but they didn't discuss that today.
Okay, all right.
What came in instead, I guess, were some weighing-ins by local businesses, including someone who runs a farmer's market and a hotel who also had opinions on this.
What is it, an aldermanic meeting? Jesus, okay.
I guess so. And Brennan basically made it clear it's not up to the court to enforce this. It would be up to law enforcement to enforce this. And Judge Kearney says she will take it under advisement. Moving on.
Okay.
By the way, huge theme of today was Judge Beverly Kearney's concerns about time. Like, I'll give you 2 minutes to talk about this. I'll give you 3 minutes to talk about this. This is somebody fighting for their life. And she's literally like, if this is going to take a long time, I don't want to do it today. Like, this was her whole stance today.
Yeah. Well, she is drinking out of that big Stanley cup. So maybe, she's like, my bladder cannot endure any more of this, Mr. Jackson.
So the next thing up was a question about the witness list. Basically, she says they've turned over their witness list with contact information on it as required by the rules to the Commonwealth. And they have not gotten contact information for all the Commonwealth's witnesses under the new rules. Brennan says the Commonwealth wants to be partially exempt because of the perceived history of harassment and intimidation of witnesses. They want to provide the list under seal. They didn't really have an objection to it. And Beverly said, I still need cities and towns because apparently that's required by the court. And that was not on the Commonwealth's witness list. All right.
Okay. Yeah.
Next one was a big one. The defense motion to allow evidence of lack of bias. This was basically where Karen Read's team is asking to be able to tell the jury who hired ARCA.
Right.
That it wasn't them, that it wasn't her insurance company, etc. Brennan went up first. The Commonwealth went up first and said the heart of this is that the defense would like to introduce them as witnesses employed by the federal government, but he thinks it's unfair. By the way, you'll hear him use the word unfair a lot. That, the Commonwealth doesn't even know why the investigation happened. We'll never have a full accounting of what impact the defense may have had on the ARCA witnesses. And his argument essentially was, and he said this investigation by the federal government, they don't know anything about it, except they do know that the defense provided them with a lot of material. So they were basically the government, the FBI, the Department of Justice, was only working with the assumption that everything the defense sent them was true. That's the argument he was making, okay?
Right, okay.
Well, he basically said that, we have DNA evidence. Their DNA evidence basically is touch DNA on pieces of shards of taillight found on 34 Fairview Lawn.
DNA?
The Commonwealth has John O'Keefe's touch DNA on pieces of taillight found at 34 Fairview. There's also touch DNA from 2 unidentified people on that same evidence. Anyway.
Drupa Proctor. No, okay, I'm just kidding.
That aside, so Yannetti basically said what the jury should be allowed to hear. We don't need them to know about what the federal investigation was about. We don't need them to know anything. We just want them to hear the truth, and the Commonwealth does not. And the truth we want to present is who hired them, that it wasn't Karen Read's insurance company, who obviously would have a vested interest in finding her not guilty. And, basically all of this stuff is based on the fact that the ARCA witnesses and report were also available to the Commonwealth, and they chose not to use them. That's a thing that we were not able to sufficiently convey at trial because we were only able to say these like murky things about them, right? And then Judge Beverly said after these arguments, if I allowed this, and I probably won't, she literally said something like that. I'm not inclined to.
Yeah.
How does this not open the window to talking about the federal investigation? And he says, well, as I'm going to say, and she said, no, answer my question. At which point Yannetti lost it a little bit. He basically said to Judge Kearney, if you wouldn't interrupt me, I'd be able to tell you what I mean.
If I allow, and I'd be very surprised if I did, mention that this was a federal grand jury and that the federal, how does that not open the door to all the testimony that Mr. Brennan just brought up that he'd be able to get into?
Okay, so first of all, and this is later in my argument, we're not asking.
So no, could you answer that now, and then I'll let you say everything.
To, Your Honor.
Oh, you just said it's late. Hold on, you just said it's later in the argument.
I know, but I said you interrupted me, and I was just about to say, but I'll address it now.
Okay.
You've seen that moment, right, Kevin?
Yeah. That was something. You know what I really love is that the clip that I saw on social media about that exchange was not the wide shot. It was a close up on Aidan Kearney wearing like a pink tie and a dark. His outfit is horrible, but his reaction, his facial expressions as this went on, yes, rubbing the face palm, the lips, everything. Yeah, it was just. I can understand why the defense and the judge have sort of lost patience with each other at this point, but.
Yannetti is usually the cool as a cucumber one, though. He really is.
Yeah.
Remember, he's the one with all the experience in Massachusetts courtrooms. Mm-hmm. He has all this stuff. He was not. And the other thing that he was unhappy about, and that the defense was rightly unhappy about, is that Judge Kearney then said, we're going to have a voir dire hearing of the ARCA witnesses next week. And they're like, why? Like, we already had that, and you've already decided to let them in. What are we voir diring? And she couldn't really explain that. But then she later then said, we don't have time next week. We will do it right before they testify. And again, the defense team was like, why? Like, what, so it was interesting. It was a whole interesting exchange. And obviously that was a kind of a big issue and will continue to be a big issue.
Okay.
Next up, you ready?
Yeah.
There was a motion filed by the defense that in this trial, both sides should have to state their reasons for objections, such as hearsay, needs foundation, etc. Yannetti's argument on this was, it's not fair to the jury or to the lawyers. It's not fair to me because sometimes you would say yes to an objection and I would have no idea on what foundation the objection was actually based on to begin with. And then we'd have to go over to sidebar and you'd explain it to me. And then all of those sidebars are not fair to the jury because they built up a resentment over the amount of time that they have to sit there not hearing evidence. Yeah. All right? Yannetti says, different judges have different opinions on this. I've argued lots of cases in this state, and I've done it both ways. There's no prejudice for basically stating the objections in court. And Bev said, denied, I'm not doing that. She ruled flat from the bench.
I don't want everybody seeing what I'm doing. I want to keep that quiet. Okay.
Right. Okay. Right. Next one, allowed without argument, defense motion to exclude false and irrelevant statements of Michael Proctor. We heard about those. Those were the things that he said on the stand that were just patently untrue. They excluded. No one had a problem with that. Motion for reconsideration of the March 6th order that was denied to exclude the Crosby expert, the dog bite expert of the prosecution. They wanted to exclude him. She included him, even though he's not a medical doctor. There's a motion to reconsider that from the defense. She's going to address that in rebuttal before he's called. So that was punting again down the field.
Yep.
Defendant's motion to prohibit the Massachusetts State Police and the Norfolk County DA from having juror contact. Judge Kearney did not like this. She's like, we've been over this. No one is ever allowed to have contact with the jurors, and no one ever has except for court officers. There's a reason why they put this motion in, right? So, I guess they just wanted it on the record.
I think probably also wants to tell the Commonwealth we're watching you.
Yes.
Because, the jurors said that this happened before, so don't think, you're smarter than we are about this.
So there's a motion here from the Commonwealth to impound juror names and IDs during trial and appoint their own stenographer, and also had a motion to impound sidebar discussions. Yannetti interpreted that as meaning all sidebar discussions, and so did Kearney, but Brennan says that's not what he meant. He meant only sidebar discussions about jurors, but Bev says that's not what it says here.
And can you clarify in this context what you mean by impounding that testimony?
Means sealing, which means it will not be released to the public or the media. So in the first trial, as of now, all the sidebar conversations are still impounded, all of them. And that is a ruling that I think Judge Kearney might reconsider. Basically, Yannetti is like, what happens in a courtroom is public information. It's important for the jurors not to hear what happens at sidebar, but that doesn't mean it's not part of the public's right to know. Yannetti questions the impoundment of that now. Why would we do that now? And Beverly said, well, you agreed to that last time, as if that matters. Last time she said non-medical doctors couldn't. She brings up what the defense did last time all the time. And any time the Commonwealth brings up something, she will rule differently or never ask them a question about last time. Ever, 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 ever. It's wild.
Okay.
So I think that is also going to be decided later. Next up, a Commonwealth motion to preclude reference to and redact the manner of death from the victim's death certificate.
Okay.
This one is wild to me. We talked about this briefly. The death certificate issued by the medical examiner for the Commonwealth of Massachusetts says, and Kevin, do you want to explain what manner of death is before I say what it says?
Yeah, I mean, there's cause of death, which might be gunshot or, accident or pneumonia. And then there's manner of death, which describes whether or not that's accidental, whether it's homicide, suicide, it's things like this. So that, you could die by gunshot, but the manner of death would say that this was homicide or this was self-inflicted or accidental, right? So when you're talking about a fatal car accident, the manner of death, especially when you are alleging in court that the manner of death is homicide because you are trying somebody for homicide, one would assume that the death certificate would reflect that.
Here, the death certificate for the Commonwealth of Massachusetts, Maria Scorti Bello, says undetermined. They want that out. The Commonwealth wants that out and cited some case law precedent where that would be redacted. Elizabeth Little for Karen Read argued this, and they said they want to exclude this because it's exculpatory. It says undetermined. She said it's also not clear if they plan to call the ME in this case. She mistakenly at first said that the ME was not on their witness list. The ME is on their witness list. But it's just like buried in the last page. Whatever. But the point that she made that was very interesting is that all the case law that he cites here, it's allowed to be redacted because it says homicide. And because it would be prejudicial to the defendant. Does that make sense?
Right. Yes.
So if it said homicide, there are many cases that say, yes, this can be redacted because it would be prejudicial to the defendant for the manner of death to be included, but there's never been a case where it's redacted when it says indeterminate.
Yeah, because it sounds like that it would be at the request of the defendant.
Correct.
To... Rebecca, we wrote a book about a homicide case in which the defense's argument was that this body that was discovered in a burn pile, that there was no way, they were arguing that this was homicide at all. And the judge's order was that the prosecution could not use the word homicide or murder.
That's right.
And I went through, went through the entire transcript with a search term. And after that, the word homicide and murder never came up again.
That's right.
But that's the benefit, right? You're talking about like it's prejudicial to the defense.
Yes.
But it seems like now the prosecution wants to turn that constitutional right on its head and say, they say we want to put our thumb on the scale here on what the manner of death was. She
works for them. She works for them. That's what makes it wild to me, right? It's not like they want to suppress it from someone else's report.
Right. But I mean, if the medical examiner determined that, they seem to be upset that the medical examiner determined it as undetermined.
Correct.
Because that's not as strong as homicide, right? So that's the thing that they want to cover up.
Yes.
Okay.
All right.
All right. Yeah. It's wild.
It is wild.
It's wild. It's madness.
Yes. All right. I got a couple quickie ones before we get to a meaty one. The Commonwealth had this motion to introduce records from the DMV. This is to be able to have witnesses identify people in the courtroom. No objection to that. It was allowed. The Commonwealth had this motion to obtain Corey records, criminal records of potential jurors. And Bev initially was like, I don't see a problem with that. And then Yannetti wanted to be heard and said, they are asked these questions at voir dire. For every other answer jurors give, we're supposed to accept their answers as truth. Why would you make an exception for this? And the only way to make this fair would be to, if the Commonwealth decides to investigate everybody, we can too, or we both reciprocally share anything that we find. So ultimately, the whole purpose of something like this is that the Commonwealth can get a jury that benefits them, and we should be given the same opportunity. And essentially, there was some agreement about that. As long as it's shared, whatever, I think there's going to be some agreement there. Okay.
So it sounds like they will use the, if this is the way the judge rules, that they'll use the criminal records to sort of vet the different jurors, but both sides will have equal opportunity to look at that information and do what they want with that. Okay. All right.
Then there was a morning break.
All right. There was a morning break.
All right. Many breaks. All right. And so then came this very meaty motion. And Robert Alessi, Karen Read's attorney who is doing this case pro bono from New York, very skilled attorney, got up to talk. Now, you might not remember this, but Bev Cannoni does not like the way Alessi argues in court, because he has this thing that he does where he says, here's what I'm going to do. I'm going to talk about these things.
Oh, right.
And he started talking, And this was about their motion to exclude this Dr. Welcher, who's this biomechanical engineer who wrote this very wide-ranging report about John O'Keefe's arm injuries, how he died by hitting his head on the frozen ground after falling backward, yada, yada, yada. He said, he started by saying, as part of my argument, and she interrupted him and said, are you going to tell me what you're going to do? And then tell me that thing? And he was like, no, I'm just going to tell you what material I'm going to be using so you can turn your page to that. Like, that's a little, because you know, she's always like, what page is that on? Blah, blah, blah. It was so unnecessarily mean. It was just unnecessary. Anyway, so the argument here from Alessi is that this witness had basically no scientific underpinnings for any of his argument. He cites no, peer-reviewed studies, et cetera, for any of the assertions he makes. But then also, many of the assertions he makes are far out of his field. He talks about pattern injury. He talks about the fact that there was no evidence that a taillight was broken at John O'Keefe's house. Basically, he's going to argue that Karen Read's taillight was not broken by hitting John O'Keefe's car. And he says things like there was no taillight found on the driveway. He's like, he's a biomechanical engineer. His report says things like the preponderance of evidence, such as Jen McCabe's testimony of Karen Read saying I hit him, shows me that X. And he's like, no, he's not qualified to do any of this. And an expert cannot talk about contested evidence. And an expert cannot give opinions about witnesses, civilian witnesses' testimony. They just can't do that, right? And Alessi said even the medical examiner in this case would never stipulate that John O'Keefe died of a fracture because his head hit the frozen ground. He said there's a 140-page slide presentation that's unintelligible, a report that references it but never explains it, et cetera, et cetera, et cetera. Brennan basically says, this is just the same as ARCA coming up with their potato gun cannon experiment, right? He also says that he would not have the witness stipulate to many of the things that were in this report and slideshow submitted by the witness. And, he compares it. He says he's exactly the same as ARCA. And then Alessi gets up and basically is like, yeah, but we're not allowed to use ARCA for these things either. So, yeah. And so, again, he said what Brennan didn't say, just like what this guy's argument is, what he didn't say is what's important here. He didn't mention the lack of methodology employed. He didn't mention any scientific literature. Instead, and I can attest to this because I watched it, Brennan just kept saying this one phrase over and over again, Judge, it's science and data. It's science and data. And Alessi's like, where's the science and where's the data? So, and Brennan kept saying, it's unfair, stop it, unfair. Anyway, okay, so that was that. No decision yet. Next motion was regarding disclosing chalks, that if either team used them, they had to disclose them. No objection. Allowed. Next was to allow an expert to provide a Cellbrite demonstration. This was a Commonwealth motion. Alessi said he needed 15 to 20 minutes to do it. Bev said that's far too long. Instead, I'm just going to do some short ones so that we can have lunch. I don't know what she's doing during her breaks, but clearly not eating. So this one was a little bit spicy. This was a Commonwealth motion to admit the victim's out-of-court statements relating to John O'Keefe's state of mind.
I think they wanted to bring in the niece and talk about, that John wanted to get out of the relationship or evidence like that.
They wanted to introduce evidence that he had maybe texted somebody or said to somebody that he wanted to break up with Karen Read, right?
Right. The implication is that it gives a motive to Karen. If she is aware of it.
That's right.
If she understands and knows that this is what his state of mind is.
And is likely to act on it.
And likely to act on it,
right.
Yeah.
Those are the two prongs here that Jackson argued. He said, these are hearsay statements. State of mind is irrelevant unless you can prove that John O'Keefe communicated these sentiments to Karen Read. And if you can prove that her reaction to these sentiments, if they were communicated to her, would be to murder him. And he made a couple of points, interesting points. He said, first of all, tons of witnesses that night said they seemed to be getting along really well. We're very lovey-dovey. Second is that Karen Read herself stipulates to the fact in many interviews she's given that she knew the relationship was not going great. And her reaction was not to kill him. It was to maybe get attention from another man. So those are like the kind of points he made there. He's like, this is preposterous. Yeah. The two of them were it was a very interesting conversation and one that involves a lot of prongs and so forth. But it was an interesting conversation. And you saw at one point, Jackson was arguing about how well they were getting along that night. And you see John O'Keefe's mom in the background vigorously shaking her head no. Like it was a very kind of heated and passionate argument, but we'll see what happens on there.
And I think this was the thing that I saw too, because then there was a lot of sort of back and forth, and I don't know if this was the argument about how one side, the attorney for one side is misrepresenting, and the other said, no, you're misrepresenting, and if you're going to bring that, if you're going to bring that, you better bring the receipts, essentially. And as Bev was ending the session for a break or for lunch, she asked both sides to stop with the personal attacks. Yes.
I will say, I have seen one side doing more personal attacks than the other.
Right.
But that is just my opinion. Interestingly, too, in Brennan's argument here, he notably said that Karen Read ran John O'Keefe over at 12:30. Again, how does that align with their argument that it was a few minutes earlier than that? And how does that align with their argument where their own expert said her phone connected to John O'Keefe's Wi-Fi at a whole different address at 12:36? So let's just put that aside, but that was something that I noticed. Lunch break, an hour of fan.
An hour of fan, yes.
Yes, very exciting moment for me. Actually, that was when I was catching up on everything because I had, real work to do, and I was a little behind. So clearly I'm taping this on my lunch hour now, and we're just getting it all in. But I had a lot of catching up to do to watch all this. So coming back from the break, Jackson wanted to make one final point about this argument beforehand. There's a lot of state of mind stuff about the fact that Jen McCabe testified that Karen knew that where they were going, 34 Fairview, was down the street from, quote, Ashley's house. Ashley was an ex of John O'Keefe's, and one of the Commonwealth's theories is that Karen was so upset about being in the proximity of Ashley's house and the fact that Jen McCabe brought up Ashley's house, that's what stoked her ire. Jackson wanted to say the she that talked about Ashley was Jen McCabe, and she said that she told John O'Keefe that. And Karen Read never knew anything about Ashley until like the next day, that it being near Ashley's house. So that's just ridiculous. Yeah, right. Okay. Yep. It's a weird little detail, but interesting. All right. So next thing up, motion against using a third-party defense.
Okay. This is a big one. This is the big part of the defense's case, right?
Third-party culprit defense is huge. And, Brennan is like, I'm going to... they've broken the rules about this last time, yada, 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 yada. And what it comes down to is they need to provide, if they're going to show evidence of a third-party culprit defense, they obviously need to provide that. At least the judge needs to be able to understand what their arguments are going to be. She asked
I think we all know what the arguments are going to be. We all understand this, Beth.
Well, what the evidence is, okay?
What the evidence is, okay.
Yes, the evidence to support it.
All right, yeah.
There's an interesting, conversation here about the fact that it is the Commonwealth's job to prove that Karen and no one else did it, right? So there's some rub there.
Yeah.
But interestingly enough...
But it's an affirmative defense, right? So it does fall on the defense to come up with this, yeah.
Right. And, the Commonwealth's objection to this is that they're just throwing shade at everyone. It's like a scattershot, gunshot situation, right?
Yeah.
And they're just disparaging people unnecessarily. And Yannetti is like, no, we plan on naming people and we have evidence for those people. And Bev says, you're going to use it at opening arguments. And he said, I'm not arguing the opening, but no, we're not. Because apparently that's a rule that they felt like they violated last time. And then she said, well, who are the culprits? Who are the third-party culprits you're planning on naming? And you could see Yannetti really hesitate for a second. And he did say, I'm really sensitive to blah, 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 blah. And she was like, well, who are the people? And he said, Brian Albert, Colin Albert, Brian Higgins in open court. It was a little bit of a moment. And then he said...
Name names.
Yes.
Named names. Okay.
He said, I'm really... And by the way, this argument was supposed to happen right after the break. It happened a little later, so I'm messing with time a little here, but I really wanted to talk about this one a little more at length. So he named names, and then there was this long sidebar. Long sidebar. He said, I need to talk to you about the evidence I have. And she said, would you be comfortable writing it all down out for me? And he's like, and she's like, why don't you just come up here and talk to me about it?
Yeah.
Yeah. Then we got a whole bunch of ceiling fan.
A whole bunch of ceiling fan.
But it was a moment that definitely caused people to perk up when he said that in court. All right. Next up, because we only have so much time, we need to get through everything. I'm being just like Bev Cannoni right now, Kevin.
All right, yeah.
So the Cellbrite demonstration that the Commonwealth wants to be able to make. He wants their expert to be able to make some sort of demonstration, some demonstrations during their testimony. The defense objection is the demonstrations they want to make are vague and not admissible, and it's all about Jen McCabe's phone. It feels like a blank check for the Commonwealth. We have no idea what the demonstration is going to be, nor does the court. It's selective. It's an argument and not evidence. And there's lots of case law to support this, even within cases by Bev, which he cited. And then Beverly says to Alessi, I appreciate your brevity, Mr. Alessi, and I will decide this quickly. Now, moving on.
Did that get a laugh?
Yes.
It should have. Yes.
But it was also kind of, to be honest, it kind of was, right?
Yeah.
Next thing is, does the defense intend to bring up any bad character or misconduct of John O'Keefe or any witnesses? This is in response to a Commonwealth motion about that. Yannetti says no, but to the extent it could go to motive or opportunity, we might do that. And a sidebar would be needed. Basically, Brennan said, we need more time to look into this, argue it without it. And Bev's ruled, you can't do this during the opening, and you can't do this without advanced warning. You need a week before any testimony, and then my ruling on that. So basically, if they want to bring up bad character evidence, say about Brian Albert or about John O'Keefe or somebody, there would need to be a sidebar and a ruling and a disclosure of a week before they do that. That was how they decided, and not in opening arguments.
Yeah. Okay.
Make sense?
Well, I can think of at least 3 people that they're going to want to do that with. Yeah. Okay.
Right.
And also Proctor, obviously.
Yes.
Yeah.
Well,
okay.
Proctor comes up later.
My God, this is a meaty readathon.
Freaking meaty. Next up, Commonwealth motion for offer of proof regarding Morrissey and the victim witness advocate Steve Nelson. These are the people that were on the defense witness list. And they also had a request to exempt these 2 people from sequestration, meaning they could attend or watch the trial. Okay. Jackson says, I have no issue with offer of proof, but there are issues around work product, and I will ask that be ex parte.
Okay.
So basically, like, why they want to bring them in would be ex parte. And he said these will be impeachment witnesses only. Beverly seemed satisfied with that, and there was no issue with sequestration. So they're exempt from sequestration, and there's going to be an ex parte offer of proof around both of these witnesses. So that's where we are with that. Bev says, the other motions are all going to be taking so much time. I'm going to give you like 3 minutes on this next one, guys. Amazing. Woman's fighting for her life. They got 3 minutes. Commonwealth motion to preclude reference to internal investigations. And then Bev asks the question of Brennan. I'm assuming you're going to need more time with this, Mr. Brennan, given the news that Michael Proctor was fired. Just came out and said it.
Yeah.
Brennan said, yes, we need more time. We have a new production from the firing. Apparently, they got the whole file from that body, that tribunal. The defense also just got that file, and apparently it's voluminous.
Voluminous.
And the defense says we need notice about what they are seeking to exclude from this information that we all just got. And they all promise to get that in a week so that it'll be dealt with on the 1st before the impanelment begins.
Okay.
All right. This is a third-party culprit thing. This is actually when they go back to that. Just timing-wise, I want you to know that I have my timeline correct. I just wanted to make sure to give that the conversation it was due. All right. So, next up, the Commonwealth motion to exclude Garrett Wing.
Who's Garrett Wing?
This is the canine expert that is now on the defense witness list. He's the guy who owns a police training school. He was a cop for 18 years. He was the head of a canine unit. Apparently, he's being brought in as some sort of dog bite expert.
For the defense.
Yes. And Bev started this with, who is this person? Why haven't you complied with all your discovery obligations? What is he going to talk about? And Alessi said, we're basically waiting for you to rule on our motion to reconsider Crosby because he's who we would bring in to rebut Crosby.
Right.
And Bev said, whether I've ruled or not, I need your discovery. Brennan's like, discovery deadlines have passed, so we need it fast. And basically, the defense agreed to give them all the discovery about this guy by Monday. So we will know more about Garrett and what they plan to do with him next week.
Okay.
All right. Yeah. Next up, this got spicy. The Commonwealth motion to exclude Michael Easter. He's the former FBI agent and head of that cell data unit. This is a Commonwealth motion. This is a defense expert who's going to come in and give his opinion on the protocols of the investigation in this case.
Oh, okay. The protocols. You mean they need an FBI guy to come in and say,
yes,
red Solo cups are
That's
not
funny.
best
You
practices.
should mention that.
Yeah?
Because Alan Jackson basically said, you and I might know that red Solo cups are not a great receptacle for evidence, but the jury might not necessarily know that. Like, they need someone to tell them what is typical and what is usual.
I like the social media pushback on the solo cups, which is like, some might say this is being ingenious and,
oh, my God. And innovative. By the way, do you know where they got the solo cups from? They got them from that same neighbor on the defense list who allegedly also had ring camera footage of nothing or something happening. Same dude. Okay. So basically, Bev wanted to know what his purpose was. Jackson argued this.
I have to assume then that the McAlberts went through all of their solo cups.
I don't know. Who knows? Well, no, he never went into McAlbert's house, remember?
Yeah. Oh, that's right.
So Bev says, she wants to know what he's testifying to. What's his purpose? Has he testified at cases before? And Jackson said he has testified in hundreds of cases before. He's been the head of investigative units. He's not just a data guy. He's the head. He's done lots of things. He's going to opine on the adequacy of the investigation, what investigations like this should look like, the fact that if somebody names another potential suspect, that person should be looked into, interviewing techniques, recording techniques, evidence logging techniques. That's the stuff we want him to talk about. So Hank Brennan, what he said into this is, by what the defense is saying then, I should be able to bring in a Massachusetts state police officer or Canada police officer to say this investigation was perfect. I should be, if that's what they're going to do.
And so I think this is a very dangerous proposition. What if the Commonwealth wants to counter and bring in a state police officer to say that the investigation was fantastic, that everybody did a remarkable job under the circumstances?
Jackson, in his second chance to talk about this, says if he wants to use a witness to bolster his argument.
He indicates that we want to use an expert to bolster our argument. There's another word for that, or another phrase for that. It's called presenting a defense for someone charged with murder. He indicates, well, what are we going to do? This guy's going to get up there and testify. What am I supposed to do? Call a bunch of other Canton PD officers to talk about how great their investigative techniques were? Yeah. There's another word for that. It's called rebuttal. That's what you're supposed to do. And then he says, well, hang on.
You wouldn't be objecting if they called somebody in rebuttal to reinforce a great investigation?
Oh, no. Mr. Brennan said, what if I called a Massachusetts state police officer to say that this was the best investigation ever? I have two words. Do it. Do it.
Do it. Do it. And then Bev had to say, personal attacks. And Jackson was like, I'm not personally attacking him. I'm repeating what he said and saying I would be fine with that. I'd be fine with it. All right. So finally, the thing that I want to mention that came up last was that there was a question about impanelment. We're all ready for that. Attorney McLaughlin, who's with the Commonwealth, she's the female attorney on the Commonwealth side who you rarely hear from. She basically said, thank God, Judge Kearney, you said you wanted this one-page questionnaire from us for jury questions for voir dire. Given the outsized publicity this case has received, can we add a second page that's only questions about pretrial publicity? Beverly Kearney, that makes sense to me. I'm guessing if the defense had asked it, there may have been more questions just from the behavior I saw today in the courtroom.
Well, I don't know. I think if Ms. Little for the defense stood up, I mean, she seems to have a soft spot for the female attorneys, which is fine. The
Either
white
a
guy
soft
isn't
spot
gonna,
or a condescending spot. It's up for debate.
Or a condescending spot. I don't know, right?
Right.
But it's interesting. We start off with this other judge who's just like, let's do this.
Asks probing questions.
Very exudes a lot of confidence in what he's doing, And so anyway, it is a tonal difference between the way Bev comports herself and runs her court. Yeah.
Yes, and also Bev's memory for what she herself has said does not seem to be consistent or intact. Period.
Well, that's why you write it all down.
Well, but she is writing it down, and then she says she read it and she reads something different than what happened. Like that's happened again and again and again. And I was talking with somebody about this today, and it's like I'm not interested in speculating about what's going on like in Bev's own mind. But she almost has the affect of somebody like with brain fog, like long COVID, like brain fog situation. It's like, what is going on with this judge, especially when you compare her to this other judge in the same courthouse? They work together. She's not below him. She's not above him. In fact, she was in charge of all the judges at that courthouse, right? She was like the lead judge. Just the affect, the brightness, the sharpness, the in the moment presentness, so different. So those are the things that happened today. As I said, the prosecution also said they filed 2 motions. One of those may have been about the legal team being added as witnesses on their list. I'm not sure, but we'll have news about what those 2 motions are in the next edition of the Readathon.
All right.
Final thoughts, Kevin?
Well, no, I'm just saying thanks for all the hard work you've done. I mean, this Readathon is longer than Crime Writers On, so I mean, it's definitely worth the Patreon money.
Yeah, let me tell you, I have a new habit. I would actually suggest listeners do this if they're interested in following some of these hearings and don't think they can sit down at 9 a.m. while they're doing other things and do this. Of course, nobody can. What you can do is put your AirPod in one ear, listen to it on YouTube like a podcast.
Yeah.
That's what I do when I'm busy typing up reports
Your hair's
or doing
long
other
so
stuff.
it can hide the ear. Yeah, that's very good. Yeah.
I also work in audio, and listening to things during the day is part of the job. So nobody asks those questions. All right, Kevin. So that's doing it for this Readathon. Obviously, we'll be back. There's some hearings going on next week again. We still have no word on the motion to dismiss evidentiary hearing or that motion at all. So that's, of course, the big cloud hanging over everything. So that's where we are.
All right.
Thanks, Kevin, for joining me.
Got it.
Partners in Crime Media.